Thank you, Plea, for inviting me to speak on mediation. I thank all the participants who have joined in today. Hope to have a fruitful session on mediation. Now, what I plan to cover is what is mediation, reference to court annexed mediation and private mediation. What are the qualification, training, and communication skills of a mediator, the mediation process, and the different models of mediation. So let's begin by understanding what is mediation. It is one of the alternate dispute resolution mechanism in which a neutral person without a decision-making power helps the parties to understand each other's points of view, facilitates communication to negotiate and resolve their dispute. Mediation is both time and cost-effective. It promotes finality and gives closure to parties. Mediation gives better control to parties to decide the outcome of their dispute rather than depend on courts, lawyers, arbitration, etc. Now, some statutes provide that dispute undergo some form of ADR before entering the court's legal framework. Some of the statutory provisions in which we will find reference to mediation and conciliation are the Section 89 of the Civil Procedure Code, Section 12A of the Commercial Courts Act, Section 30 read with Part 3 in the Arbitration and Conciliation Act, conciliation under Section 4 of the Industrial Disputes Act, Section 442 of the Companies Act, Section 74 of the Amended Consumer Protection Act, conciliation under RERA, and the Family Courts Act. Now we'll understand what is court-annexed mediation and what is private mediation. When court refers matters to mediation, we generally call it court-annexed mediation. In court-annexed mediation, if the court finds that there is an element of settlement, then the court will refer the parties to mediation, of course with consent of parties. The high courts have framed ADR rules, and it is the referral judge or the mediation center which is annexed to the court who appoints the mediator or a mediation institution on its panel on a roster-based system. Mediation is usually done pro bono and conducted within the court premises. Now, in pre-institution mediation under the Commercial Courts Act, it is the state or the District Legal Services Authority in consultation with the Mediation Monitoring Committee of the court, which is entrusted with pre-institution mediations. The authority appoints the mediator or a mediation institution on a roster system basis from its panel, and the mediator fees is dependent on the quantum of amount claimed, as specified in the schedule of the Pre-Institution Mediation and Settlement Rules of 2018. Now, the advantage in court-annexed mediation is that the litigants do not feel abandoned by the justice system. If the matter gets settled, then the settlement agreement is enforceable as a decree or an award of the court. And if there is no settlement, the case goes back to court for proceeding with trial. Now, in private mediation, a professionally trained and qualified mediator or a mediation institution offers mediation service on fee-for-service basis to the court, to members of public, to the members of commercial sector, to government sector, to resolve disputes. I am part of an organization which is called Association of Mediation Practitioners, which is a mediation institution which is empaneled both on the main mediation center at Bombay High Court as well as in the City Civil Court at Bombay. So we do both court-annexed mediations as well as private mediations. So when we do private mediations, we have our own set of rules and we follow those rules to do private mediations. Usually in private mediations, parties are required to sign an agreement to mediate or at least a non-disclosure agreement. Matters which are already pending in court as well as the pre-litigation disputes can be referred and resolved through private mediation. Now we'll understand what are the qualifications and training required for a mediator. Now the ADR model rules provide that certain individuals are deemed to be qualified to be appointed as mediators. Now, who are these deemed to be appointed individuals? They are the retired judges of the Supreme Court, the High Court, the District and Sessions Court, experts or professionals having 15 years of experience, advocates with 15 years standing at the bar, retired senior bureaucrats and executives. Also mediation institutions, provided its members are approved by the High Court. Now, training is very important and required irrespective of the background, whether he be a judge or advocate or from any other background. A minimum 40-hour mediation training program is a bare essential training which is mandated. However, this is not enough. Advanced trainings are definitely required to be undergone to become a very effective mediator. Now, in our trainings through role plays, mediation, co-mediation, shadowing of a mediator, with permission of parties, impart practical training to mediators. Being conversant with certain concepts of psychology, particularly the behavioral sciences, adds some robustness to the skill of a mediator. Mediator's domain knowledge, that is his subject expertise and process expertise, do have an impact during the mediation process. Process expertise is prerequisite to domain requisite. Now you will find that these days, the minute students or advocates who undergo 40-hour mediation training program make assertions that they are expert mediators. So therefore, nowadays in mediation circles, we are having this conversation whether there is any need to have an independent arbitration body who will be interested with the task to recognize and certify mediation trainings, trainers and training institutions and mediators basis their training. Now, what should one look in selecting a mediator? While selecting a mediator, select a trained mediator who has process expertise. Ascertain which model of mediation is being followed by him or her. Most mediators will follow an eclectic model to suit the needs of parties. Now, there are three basic models, which is the facilitative model, the evaluative model, and the transformative model. We'll talk about it a little later. Some others openly accept that they are facilitative in the beginning and tend to be more evaluative as the process moves towards closure, particularly when parties request mediators' suggestions. Now, sophisticated users of ADR consider whether their dispute requires a specific legal expert or industry, scientific, or technical expert, which can make a difference in the outcome of mediation. The advantage of domain knowledge is that it allows the mediator to make an independent judgment which both parties respect and help them to adjust their demands and be reasonable in negotiation and thereby resolve the dispute. Disadvantage is that it may interfere with active listening skill of the mediator. The mediator may make hasty conclusions, offer suggestions too early in the process, especially when it is not required, and it may deprive the party of their own power and the ability to resolve on terms that make sense to them. Because we have to remember that mediation lays great importance on self-determination by parties. Now, what are the communication skills of a mediator? Mediators' interpersonal communication skills play a significant role during the mediation process. Asking the right questions. Questions, as we know, can be open-ended, close-ended, probing questions, hypothetical questions, and so on. Probing questions elicit crucial facts and uncover unexpressed feelings. Asking the right questions may at times allow a party to express his feelings for the first time after the dispute has erupted. Open-ended questions allow a party to respond giving his own perspective of the dispute and coming up with his own unique solution. Emotional outburst in the beginning of the process may help a party to relieve and move forward and actively engage in the process, but the same outburst during the final stages of negotiation may result in an impasse. So the skill is to ask right questions at the right time. In practice, the mediator will use broader questions at the beginning to extract all relevant information and then narrow down the scope of responses by asking close-ended questions as the mediation moves towards final stages. To manage the process, close-ended questions may even be useful in gaining control of the process or to move negotiation on a different topics. Now in trainings, mediators learn that they need to not let go control of the process. So therefore, close-ended questions sometimes are useful for this purpose. Another important communication skill of the mediator is active listening. It is the skill to summarize and reframe. To summarize is to capture the key ideas of the speaker. To reframe is to reword what is communicated in neutral language so that the others in the room hear it as constructively as is possible. Active listening by mediator helps to build rapport and trust. The NLP model of communication is a very useful guide for mediators as to how to process incoming information. As humans, we do one of the three things: distort, generalize, and delete to deal with the incoming information according to our unique filters to confirm our worldviews. Mediator in his training understands what are his filters which are unique to her or him, and also learns to keep these common barriers to active listening such as distraction, absent-mindedness, and internal chatter to a minimum. The next very important communication skill of a mediator is to listen with empathy. Empathy is the capacity to place oneself in another's position. Mediator will reflect back to the party that their feelings and emotions are recognized and understood without judgment. Empathy allows party to embrace vulnerability. Now, Brené Brown, a researcher who has studied emotions for a number of years, discovered that vulnerability is the cradle ground of creativity. In private session, the parties get a chance to drop their guard and be vulnerable without the other party knowing and exploiting the situation. Recently, in one case that I mediated, the party's wife disclosed that the party was having a serious health issue and both wanted the dispute behind them so that their stress can get reduced. They did not want this fact to be disclosed to the other side because they apprehended that the party could use it to his advantage to bargain hard and tire out this party. So mediator manages the tension between empathy and assertiveness, because assertiveness is definitely required in the negotiation stage. Another important communication skill is the use of appropriate body language, symmetry of posture, appropriate facial expressions, leaning gently towards the speaker, and maintaining proper eye contact. Now, studies reveal that 55% of the meaning is transmitted through body language, 38% through attitude and demeanor, and 5% through spoken word. Now we'll understand what is the mediation process. Now, mediation has a structure, but it is flexible. The stages may go step by step, or it may overlap. The first stage in mediation is the initial contact with parties to seek their consent to move forward. At this stage, conflict of interest has to be checked and overruled. Now, what is conflict of interest? If the mediator has any interest in the subject matter of the dispute or from any relationship with the party, whether past or present, personal or professional, that reasonably raises a question of a mediator's neutrality and impartiality. So a party who wants to raise an objection about the conflict of interest has to specifically waive the objection. Only then the mediation will proceed. Then the mediator will request both parties to provide a statement which will contain a brief background of their case, law applicable, market standards or trade usages, to inform and persuade their point of view. The statement will assist the mediator to understand two sides of the same events. Now, if it is a court proceedings, generally parties forward to the mediator the pleadings, which in nutshell gives what is the dispute all about. Then the mediator may or may not, sometimes he may, schedule a pre-mediation conference, especially if it is a family dispute or a matter referred from a family court, to assess and get a sense of how receptive and resilient the party is to engage in the process. The next stage is the joint session, when parties come face to face with each other in the presence of the mediator. The session begins by the mediator welcoming and introducing all persons seated at the table. The mediator checks whether the person attending has authority. If the representative of a party is in attendance, the mediator will make a mental note to check and ensure during the process that the representative has complete information and is also aligned with the interest of the party. Often the representative may not have complete information or may not be aligned with the interest of party if he or she has his own or her agenda. Mediator therefore manages the tension or the conflict between the principal and his agent. Then the mediator will make his opening statement. The opening statement in nutshell is setting of the ground rules. He will request parties to listen, not to interrupt, to be civil and polite, basically not to use any verbally abusive language. Explain the mediation process and the role of the mediator. The role of the mediator is to remain neutral and impartial throughout the process and not take sides. Mediation is a voluntary process, and therefore a party is free to withdraw and walk away anytime. Mediation is private and confidential. No steno, audio-video recording is permitted. What transpires during the mediation cannot be used outside of mediation or relied upon in any other proceedings. Mediator cannot be summoned as a witness. Parties cannot file any proceedings against the mediator. Parties are alone responsible to make the decisions. Mediator controls the process, and the parties control its outcome. Mediation places great importance on self-determination by parties. After the opening statement of the mediator, he will invite both parties to make their opening statements, in which express their feelings and emotions and the consequences that they suffered, financial or otherwise. It is imperative at this time that the other party listens, does not interject, remains silent, and takes notes to respond later. Sometimes if the advocates are present, they may also make supplementary statements giving a gist of the legal case. Then the mediator will refrain and summarize the key points and identify the issues that need resolution. He will highlight the common grounds without sidestepping the differences. The parties now understand the points of view of each other, the obstacles and possibilities for potential settlement. The parties themselves decide the agenda and the order in which the issues will be taken up for discussion. Mediator will ensure that all issues on the agenda are dealt with thoroughly. Mediator creates a setting for parties to talk directly to each other. If the dialogue does not make any progress, then the mediator will suggest private session. In private session, the party gets a chance to respond and react to the joint session and often share confidential information which the party was not comfortable to share in the presence of other. Mediator will hold such information in confidence and disclose to the other party only if authorized. Mediator will probe parties' underlying interest, what the party really wants out of mediation. Now, position is the surface statement of what the party claims or demands as its entitlement. Interest is the underlying reason or value, concern, fear, aspiration, motivation, or just an objective need. Example, a workers' union demands a 5-year contract, which is a stated position. The union actually wants time for workers to retool their skills before the plant closing is implemented, which is the underlying interest. Take a case of a wife filing a domestic violence case. Her legal case is her position, but she actually wants divorce, maintenance, and child support, which is her underlying motivation and the real interest in filing the case. Now, the mediator will also assist the parties to do reality testing. Without disturbing the attorney relationship, the mediator will probe about the likely success in litigation or arbitration and what other better alternatives are available if they choose to walk away. Basically, the Bhatna, Vatna, and Malatna. Bhatna is best alternative to negotiated agreement, Vatna was the alternative, and Malatna the most likely alternative. At this stage, the mediator will also check if there is advocacy bias, meaning selective perception. The fact that most parties spend substantial amount of time in identifying their strengths rather than weaknesses and focus attention on discrediting the other side's case. I recently read an article that Harvard MIT study concluded that it is impossible for a lawyer or a client with an interest in the outcome of a dispute to make an objective settlement assessment. So now with reality testers have a very realistic perspective of the range of outcomes which nudge them to consider the consequences should they choose to walk away and pursue legal remedy in terms of costs and benefits. Mediator will check with each party what he or she wants, is willing to offer, and realistically deliver. The classic role of mediator is to articulate what neither side will propose directly. A party may request the mediator to make a proposal as if it was coming from the mediator and it was the mediator's own idea. So after reality testing with each party in private session, the mediator will go into the next stage or the next session, which is the negotiation stage, which may happen either in a joint session or in a private session. Negotiations comprise of breaking impasse if there is one, and bargaining and reaching agreements. Now, brainstorming is to generate as many options as are possible and then writing them down. Options are evaluated on objective criteria basis. Now, it is important to remember that not everything can be evaluated on the objective criteria. Something may have a very sentimental value. Like I had a case in which in a brother-sister dispute, the sister had a lot of sentimental value for the agricultural property which the brother sold off without her consent. So then that we mediated and the matter got resolved. But sometimes it is not possible to evaluate. And the mediator will have to assist parties to look into other areas of commonalities. The mediator will assist parties to accept options and solutions that meet interest of both parties. Offers are given, counter offers are given, and there may be some deadlock which the mediator will help parties to move forward. After some bargaining, the parties may reach agreement. Now, during bargaining, we will find that there are three types of negotiators: soft bargainers, hard bargainers, and principled bargainers. Soft bargainers give in and make sacrifices to get something in return. Hard bargainers start with their position and very high demands, and will painstakingly concede slowly, little by little, fighting for every penny. In mediation, bargaining is based on principled negotiation. The principles are: separate the people from the problem, be hard on the problem but soft on the people, move from an adversarial approach to a collaborative approach, move from the past to the future, move from position to interest, avoid blame game, and find creative solutions. Now, bargaining again can be distributive or based on integrated interest-based bargaining. In distributive bargaining, the parties agree to distribute a fixed resource, divide assets. It is based on position and rights. Because parties have not explored the underlying interest, creative solutions are not explored. To give an illustration which is often repeated in mediation trainings, two sisters fighting for an orange. With distributive bargaining approach, both the sisters will decide to divide the orange into half, each one getting half an orange. So that is distributive bargaining approach. Interest-based bargaining, or in other words, integrated interest-based bargaining, is based on facts, laws, needs, and interests. It creates joint value for both parties by enlarging the pie or sweetening the pot. To illustrate the same orange example, now the mother intervenes to mediate between the two sisters, and the sister learned that one sister wanted the orange to eat it, whereas the other sister wanted the peel of the orange to use it in a cake. So now when they discover the underlying interest, both are able to get what they want. So the classic role of a mediator is to help parties to find each other's interest, create value, distribute value by expanding the pie. Now, if the mediator discerns that the parties are not able to negotiate collaboratively, the mediator will place both parties in separate rooms, and the mediator will carry the settlement proposals back and forth between parties, known as shuttle diplomacy. If the dispute is only about money, the mediator will help parties to identify the settlement ranges and establish tentative bottom lines. Sometimes matters get resolved when one party offers a genuine apology and agrees to offer terms to make amends. Mediator will sometimes come across a party who will insist on receiving an apology as a face-saving device. If the bargaining then results in acceptable terms, the settlement is reached. Once the settlement terms are agreed, the parties will be brought together to sign the agreement. Now, when we are discussing negotiation, mediator often comes across different negotiating styles that the party use in negotiation. Disputes differ in the way it intensifies, spreads, and gets diffused. So, what a mediator typically encounters, and it could be a combination of one or two negotiating styles. The first is the avoiding style. The party is unassertive and uncooperative. The party does not confront the problem or address the issues. At times, because negative emotions are so discomforting, a party may not be emotionally receptive to engage in the process. It could be due to trauma or recent loss or any other psychological reasons. It could be on account of firm position taken in court. Take a case of a motor accident involving negligence where death has occurred, or a case where document is fabricated, or a domestic violence case or harassment at workplace. Avoidance may manifest in many different ways. Party may not attend or pretend nothing happened, denies or justifies their own conduct, blames the other, or downplays or ignores the existence of the dispute. Sometimes a party may come, sit and cry, or simply stonewall. So mediator in the private session will try to probe and understand by creating a safe space for the party to offload and express and think rationally. But despite all efforts of the mediator, if the party does not want to participate, it has to be respected, because ultimately mediation is a voluntary process. Another style that the mediator will come across is the accommodating style. The party is unassertive but cooperative. The party does not insist on his own interest but accommodates interests of the other, which although hastens the mediation process, but will result in one-sided agreement, which will only breed resentment later. The mediator in private session will ask probing questions to enable the party to understand and confirm whether the proposed settlement will really serve his underlying interest. Another negotiating style is the compromising style, in which a party is moderately assertive and moderately cooperative. The party recognizes that both sides have to compromise by giving in and losing something. Party will try to find common ground by splitting the difference, as we saw in distributive bargaining approach. This may result in both parties partly satisfied and partly dissatisfied, as we saw in the orange illustration. By dividing half an orange, both sisters got partly satisfied and partly dissatisfied. Parties get less than what they want, or worst, the more powerful may soon be back for more. Another style is competing style, where the party is assertive and uncooperative. Party values his own interest but does not care for the interest of the other. He is aggressive during meetings and insists on meeting his demands. He holds his ground and does not shift from his position. He believes that the only option is for the other side to give in to his demands, failing which he will go to court. This attitude does little to repair relationship and breeds mistrust. The mediator in the private session will assist the party to consider his bhatna, to check if his position is really meeting his underlying interest, and coach him to collaborate with the other side to find amicable solutions. Another style is the collaborative style, where the party is assertive, cooperative, and constructive. The party values his own interest, but also the interest of the other. He participates in negotiation and works towards mutually acceptable solution which satisfies interest of all to the extent possible. Now, this is a mediator's delight. If the party is collaborative, then it makes the mediator's job very easy. But that is not the case usually. Now we'll discuss the three models of mediation, which is facilitative model, evaluative model, and transformative model. In facilitative model, as the name suggests, the role of the mediator is to facilitate. Mediator makes no recommendations or evaluations or imposes his decision. Now, what I discussed earlier is basically about the facilitative model. Mediator will make no recommendations or evaluations or impose his decision. The mediator encourages party to reach agreement by exploring each other's deeper interest, as it is based on the principle that the parties have the best understanding of what they need for themselves and from each other. The mediator offers a structured process for the parties to make best use of, and the parties are encouraged to negotiate and bargain based on their interests rather than on positions or rights. This model is most suitable where relationships are to be maintained and strengthened, like workplace, community, neighbors, family, partnership, etc. Another model is the evaluative model. The mediator encourages parties to reach settlement according to their rights and entitlements within the anticipated range of court remedies. Mediators give recommendations to parties as long as it does not violate impartiality or self-determination of parties. Mediators are likely to help parties to assess the legal merits of their arguments and make fairness determination. This model is often used in court-mandated mediation, and the mediators are often advocates who have legal expertise in the area of dispute. This model is also suitable to business and contract disputes where there is no desire to preserve relationship, but part ways on amicable terms and where a compromise is sought rather than going to court. It is also suitable in divorce mediations when couples decide to divorce by mutual consent and agree on terms of maintenance, custody, and child support. Another model of mediation is the transformative model. This is a very less structured model. It focuses on two key interpersonal processes: empowerment of parties and recognition. Recognition by each party of the needs, interests, values, points of view of the other, as a result of which relationship is transformed. Parties are encouraged to deal with the underlying causes of their problem with a view to repairing their relationship. Parties structure both the mediation process and its outcome. The mediator follows their lead. Now, this is a very idealistic model and very, very useful when relationships are to be repaired and strengthened. For example, a married couple having problems in their marriage. Instead of going for divorce, they decide to stay together to work out the differences in their marriage, to peacefully coexist and raise a family. This is also useful in community disputes. So now, in a nutshell, we have understood the mediation process and the different models. All cases of civil nature are suitable for ADR processes. Now, in the AFCON's case, the Supreme Court has clarified that certain matters are not suitable to be referred to ADR under the process of Section 89 of the Civil Procedure Code. They are the representative suits under CPC, as it involves public interest or interest of numerous persons who are not before the court. Cases relating to election to public offices. Cases involving grant of authority after inquiry, for example, grant of probate or letters of administration. Cases involving serious and specific allegations of fraud, fabrication of documents, forgery, impersonation, coercion, etc. Cases requiring protection of courts, for example, claims against minors, DTs, and mentally challenged persons. Cases involving prosecution of criminal offenses. So these are certain cases which are not suitable for mediation. So I end here. Thank you all for listening in.
Ma'am, how do we pursue mediation after law, and how do we get ourselves certified?
Okay, as students, I would recommend that you take part in the mock mediation competitions. Even if you are not taking part as a direct participant to compete, at least participate in organizing the event, which will really help you to get in touch with the assessors who come. And if you happen to get an opportunity to remain in the room where the competitions are happening, you will pick up a lot of skills. As far as training is concerned, I think many institutions are now imparting mediation trainings. So, and I am happy to help over an email as to what options for trainings can be considered.
Another question, which is again related to the first. How do mediators deal with stubborn parties who are unreasonable and want their own way?
Yeah, so we have to engage in the art of advocacy and the art of persuasion. Probe and probe and probe till you discover their underlying interest and do reality testing. And ultimately, we have to remember that mediation is a voluntary process. And if the party does not want to budge, despite all good efforts taken by the mediator, at the end, the mediator has to respect it. And also one thing I have to point out that, you know, settlement is, reaching settlement is not the benchmark of efficiency of the mediator. Because every dispute has its own life cycle. So if the mediation is tried at the very inception of the life cycle of a dispute, the parties may not agree to settle. But eventually, at some point in the stage of the cycle, the parties will settle.
Okay. I think there is a question of time limit within mediation. Is there an outer time limit wherein mediation?
Yes. Like in, if it is a court annex mediation under 89, then you have to complete your process within 60 days as per the ADR rules and the of the Bombay High Court. And if it is a pre-litigation matter, the pre-litigation settlement rules provide for 3 months with extension of 2 months by consent of parties. And if you still can't, then if you go back to court and say that, you know, we really think that we can work out our differences and we need more time, the court is more than happy to give time.
Okay. Another question is, how do parties eliminate the dispute over hiring an unbiased private mediator? Because if one party hires, the other party thinks the mediator is biased.
Yeah, that we as mediators, even in the session, we encounter this a reactive devaluation. Just because the other party has appointed, this party tends to feel that, that he's appointed the mediator, so the mediator is definitely not going to be neutral. But then you have to find out the background of the person who has been appointed, and if the mediator has a stature in the mediation field and is known to be neutral, despite whoever is appointing him, that should take care of this apprehension. But ultimately, the control is in your hands. Just because one party is suggesting, you still have the control and the opportunity to say no and suggest your own names, 3 names, and tell that, okay, hey, look here, I am not agreeable to this name. I have these 3 names. Why don't you consider them?
Okay. Another highly voted question is, can lawyers without license become mediators? Basically, can a non-lawyer be a certified mediator?
Yes, non-lawyer can definitely be a mediator, because even our ADR rules contemplate a person who is not an advocate or a judge to be appointed as a mediator. But there is a qualification that the person has to have 15 years of experience. And a lot of young students, especially those who are very passionate about mediation, who undergo training, feel very disheartened that the courts are not wanting to empanel them because they don't have the 15 years of experience.
What is the success ratio of mediation in India?
Oh, those statistics, I don't have it right now, so I really can't make any comment.
Okay. Are there examples of mediation relating to property disputes of joint family?
Yes, property disputes of joint family are very, very, amenable to be settled through mediation. In fact, it is the best model to resolve your dispute rather than go to court, because you never know what the court will decide, because court is going to decide on the rights according to law. But in a family, in a mediation of property dispute, the parties can decide, like I will share a case in which there was a brother-sister dispute. The suit subject properties had 3 properties. Ultimately, the sister got a property which was not part of the suit, but which stood in the name of the spouse of the brother. So it gives you a lot of maneuverability to decide and address each other's needs.
Do mediators call in experts of a particular field should the need arise?
See, the ADR rules do provide that expert can be called. Supposing if it is a very complicated case of valuing the shares and control of a company. Now, the mediator does not have the expertise to understand whether X amount of value placed on the shares is fair value or exaggerated or low value. So therefore, there is a need to call for an expert valuation report to understand that the value of the share consideration is fair.
Okay. Another question is relating to this lockdown. Would this lockdown period be excluded in pre-litigation mediation, or do parties have to approach for extension?
No, I think parties, and there are so many webinars happening on this issue. So since we are talking about mediation, I don't think I want to digress on that topic. It is a topic for another session itself.
Sure. What happens if one of the party does not comply with the decision of the mediator?
So if it is a court annexed mediation, then the mediator files a settlement report in court, and it becomes executable as an award or a decree of the court. In pre-litigation matter also, it is filed in the court and it is executable as such. But if it is a private mediation, then it is like any other contract and it is enforceable as such.
Another question is relating to the costs in mediation. What is it normally as cost? Are they fixed cost or how are they?
The court annexed mediations, all the empaneled mediators are doing pro bono work. So there is no fees that are paid to mediators. In pre-litigation, some very nominal fee is being paid. In private litigation, mediation, the sky is the limit. It could be anywhere from 10,000 to 1 lakh to 3 lakh, depending on the stature of the mediator.